everyone, and thank you for joining us today. My name is Michaela Romesser, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time and we'll talk about extraordinary ability visas, which are O-1A, O-1B visas, and then EB-1A and NIW green cards. A few things before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals pursuing various types of visas and green cards. And we can assist you with family-based, employment-based, and investment-based visas and green cards. We regularly process a high number of O-1 visas and EB-1A and NIW green cards. We'll continue to have this webinar series, and we'll have at least 2 webinars a month on different visa topics. So please join us in the future for our future webinars. At the end of this webinar, we'll send you out a few things. So we'll send you this PowerPoint we'll be using during this webinar. We'll also send you our comprehensive visa guide, so you can take a look at that. We'll send you a link where you can sign up for additional webinars we'll have in the future, and we'll also send you a link where this webinar will be recorded. This webinar will also be available on our YouTube channel, and we encourage you to subscribe and hit the notification button on our YouTube channel, as we often post new immigration videos. And finally, we'll send you a link where you can sign up where you can schedule a consultation with one of our attorneys to discuss your particular case. Today we are lucky to have Jiyae Hwang, who is a senior associate at Scott Legal PC, and she has a vast experience with NIW green cards, but also O-1A, O-1B, and EB-1A green cards. And as I mentioned, my name is Michaela Romesser, and I'm a senior associate at Scott Legal. And finally, if you have any question as we go through the presentation, please feel free to post it in the Q&A box, or you can just put it in the chat box, and then we'll get to all questions at the end of the webinar. Perfect. So why don't we get started? So first, we are going to get started with just kind of general overview of O-1 visas and the EB-1A green card. So O-1A visa is a non-immigrant visa for individuals who have extraordinary ability in the field of science, education, business, or athletics. And the standard for an O-1A visa is basically that you have to show that you are one of the small percentage of people who have arisen to the very top of your field. Then an O-1B visa is also a non-immigrant visa, and the O-1B visa is reserved for individuals who have extraordinary ability in the field of arts, or who achieve extraordinary achievement in the field of motion picture or television industry. So basically, the O-1B, we call it kind of like an artist visa because it's mostly reserved for the people in the arts industry. So the standard for arts and the standard for the motion picture television industry is a little bit different. So the standard for the people who are in the arts industry is that these people have to have received a distinction, which means a high level of achievement as evidenced by a degree of skill and recognition that is substantially above that ordinarily encountered. And they, for the O-1B, we generally have to show that the people or the artists are prominent, leading, or well-known figures in their particular industry. The standard for the motion picture television, so the standard is a little bit higher, and the applicant has to show that that again, like he's kind of like arisen to, and he's basically like substantially above, has achievements substantially above those his peers achieved. The EB-1A green card is a green card. So, the green card basically gives you ability to reside in the US permanently, as opposed to the O-1A and O-1B visas that are just temporary visas you have to renew every couple of years. So the EB-1A green card, you can apply for it if you have an extraordinary ability in the field of science, arts, education, business, or athletics. So any field, as mentioned here. And the standard for the EB-1A green card is basically the highest, because the government wants to reserve the green card really. For people that have achieved to kind of like the top of their field. So the standard is that, the individual has to be in one of the small percentage and has to, and we would have to show that you are in the top of your field and you have sustained a national or international acclaim and your achievements have been recognized in your field of expertise. And the last category, Jiyae, we'll be talking about here is the national interest waiver, and that is also a type of green card, and this would give you an option to reside in the US permanently. Perfect. So now let's discuss the O-1A visa in a little bit more detail. So how can you qualify for an O-1A visa? So, you can either show that, if you have received kind of like a major internationally recognized award, such as Nobel Prize or, like one of those well-known awards, you could qualify for an O-1A visa just based on that award. You wouldn't have to submit much of other evidence, because just evidence of that would be evidence that you have met the O-1A standard. If you don't have such an award, then you will have to meet 3 of the following criteria. So one thing to keep in mind is that some people see the criteria and they're like, oh my God, like I don't meet all of them. You don't have to meet all of them. You just have to meet 3 of these of these criteria. So the first one is, receipt of nationally or internationally recognized prizes or awards. So here, basically, we would have to submit evidence of the award. So, normally it would be a photo of the award. And then, we would want to submit evidence that the award or prize you received is nationally or internationally recognized. So we would want to include some information about the organization that gave you the award, and then some evidence of kind of like like who won the award in the past, like what are these people, like well-known people in the industry, and just kind of some more detailed evidence about the award, like who. What are the criteria, like how did the organization decide to give the award to you, and then some background about the organization. The second criteria you could meet is evidence that you are a member in associations in your field that require outstanding achievements. So here, we would kind of like want to submit evidence about the about the association, about the organization you are a member of. We would want to show that, this association organization is kind of like well-known, really well-known in the industry. And we would also want to kind of like submit evidence, showing how they select their members. So, like if their website or, like if basically anyone in your industry can become a member of this association or organization, it may not be that helpful to include, but if they have kind of like a kind of like rigid criteria, they require that all members have achieved like certain achievements in their industry, then it would be very helpful to include for in your O-1A visa application. Another type of evidence we could submit is evidence about published material in professional or major trade publications, newspaper or other major media about you and your work. So here, if there are any like interviews with you published in any media or any articles about your work, about the projects you did, we could submit that. Some of our clients are concerned that, like let's say that someone is, like an architect or, or like kind of like did some projects and then the media articles kind of like don't mention the person's name directly. That's usually fine. We would just kind of like, we could still submit that article. And then we would just kind of like need to submit some additional evidence that would tie you to that particular project. Next type of evidence, we could submit is evidence of your original scientific, scholarly, or business-related contribution of major significance to the field. So here, it's for example, like if you have a patent or if you came up with some kind of like a new original process and it had significant impact on the industry, we could submit evidence of that. Another type of evidence we could submit is authorship of scholarly articles in professional journals or other major media. So this is if you yourself, like wrote some articles, we would submit evidence of those. Another type of evidence we could submit is evidence that you have a high salary or other remuneration for services. So here, if your salary is kind of like really high as compared to the kind of like the standard in your area, we would submit evidence of that. We could submit evidence such as like if you worked in the US, we would submit W-2s. If you worked in your home country, we would kind of submit some sort of equivalent to the W-2s or your tax return. Showing your salary or kind of like payroll reports that kind of just, like list your salary. And then we would submit some sort of evidence that would indicate that, this is the standard salary for, like your occupation in this particular area and your, the salary is this. And then we would submit evidence of your salary and argue that, that your salary is kind of like much higher than the standard where you're currently working for your occupation. Then another type of evidence we could submit for the O-1A is evidence that you participated on a panel, as a judge and you judge the work of others. So this is, for example, like let's say that there is some sort of, like competition in your industry and you were selected to judge the work of others. This would be, this we could include in the O-1 application. Again, we would want to submit evidence about the organization or association that organized the competition. And again, to kind of describe the criteria, like how they select the judges. Because again, we would want to show that not everyone can become a judge in this competition, but they really kind of select, people who are on the top of the industry to be the judges in the competition. And then, the last type of evidence we could submit is evidence that you are or you were employed in the past in a critical or essential capacity for organizations or establishments that have distinguished reputation. So, here we usually submit, if you worked or if you're currently working for like a famous, organization in your industry, we would generally submit a letter from that organization, describing, like why is the organization kind of like, like why does the organization have distinguished reputation, is well known in the industry. And then the letter should also explain kind of like your role for that company. And, we would have to show that your role was either or is either critical or essential for that particular organization. Okay, so now let's discuss the O-1B visa. So the O-1B visa, so how can you qualify for the O-1B visa? you would have to submit evidence that you were either nominated for or received a significant national or international award or a prize in your particular field. So as I said, the O-1B visa is, generally for artists. So, if you receive, for example, or if you were nominated for Emmy or Grammy Award or another, kind of like a well-known award like that, we could submit evidence of that, and you wouldn't have to go through all these other criteria. If you don't have such a well-known award, then you will have to show that you meet at least 3 of the following criteria. So the first one would be evidence that you perform a lead or a starring role in production or events that have distinguished reputations. So this is, for example, like let's say that you are a designer and, like interior designer and you design some kind of like a well-known project. And, then we would submit evidence of that. Another type of evidence we could submit is evidence of critical reviews or other published material in professional or major trade publication. So this would be kind of like similar type of evidence that I already described for the O-1A. Here we would be basically submitting, articles from different, newspaper or, like online articles about you or your work. These could be either interviews with you or just kind of articles generally about you or your kind of like the work you did in your industry. The third type of evidence we could submit is evidence of performance in a lead, starring, or critical role for organizations or establishments with distinguished reputation. So again, this is kind of the similar type of evidence as I already described for the O-1A. We would be submitting letters from your current employer or your past employers. And again, we would have to show that, these companies, these organizations have distinguished reputation, and again, kind of like describe your role for these companies. The next type of evidence we could submit is evidence of a record of major commercial or critically acclaimed success in the performing arts, as shown by box office receipts or record, cassette, compact disc, or video sales. Next type of evidence we could submit is evidence of significant recognition for achievements from organizations, government agencies, or other recognized experts in the field. So this type of evidence is what we called, expert letters. So here, we would submit a few letters from certain experts in your field that would have to attest, to the fact that you are, you are qualified for the O-1B, and you are, you achieved all these achievements, and you are meeting the O-1B visa standard. Another type of evidence you could submit is evidence of having commanded a high salary or other significant high remuneration for services. So again, this would be similar type of evidence as for the O-1A. And or you could submit other comparable evidence. And this is kind of like a difference between O-1B, O-1A. Because the O-1A has kind of like very set, criteria. You have to meet 3 of those. I believe it's like 3 of 10. But for the O-1B, like if you work in a field and like, let's say that, like these criteria or this type of evidence that just went over, it just doesn't apply to you or your industry, you could still submit, like different evidence. And still argue that you qualify for the O-1B and you meet the O-1B visa standards. So now let's go over some differences between the O-1A and O-1B visa. So the key difference is that kind of like the type of field you're working in. So the O-1A visa is really, for people who work in the field of, science, education, business, or athletics. And the O-1B visa is for artists and people who work in the motion picture and television industry. You know, the standard for these two visas is also different. So the standard for the O-1A is that you have to be one of the small percentage of people who have arisen to the very top of their field. So you know, the standard for the O-1A is pretty high. The standard for the O-1B visa is kind of a little bit lower than the standard for the O-1A. So the standard for the O-1B, the people who are applying in the arts category, is that they have to show that they have a high level of achievement as evidenced by a degree of skill and recognition that is substantially above that or ordinarily encountered. So you see that, you know, the standard is much lower than the O-1A standard. And the standard for the motion picture television industry is that you have to show that you have a level of acclaim that is substantially above, you know, that of your peers. Now, you know, for how long can the O-1A or O-1B visa be issued for? So both of them you can initially get for a period of 3 years, and then if you are renewing the O-1A or O-1B visa, you can renew it for a period of 1 year. So you can do a 1-year extension, or you know, what we sometimes do is that if you are able to show that you'll be kind of working on a new set, you know, you have a completely new itinerary, you'll be working on complete kind of like new set of projects, and we are able to show you know, itinerary for a period of 3 years, we can kind of like file it as a new petition as opposed to extension petition. And then you would be able to get another 3-year in O1 status. So you know, initially you can get it for 3 years, and then we would kind of just have to you know, like look at your future engagement and then kind of decide, you know, like would this be filed as an extension or kind of like a new O1 petition. And you know, can your family come to the US? So this is the same for O-1A and O-1B visa. So yes, you know, your spouse can come to the US, and your children who are unmarried and under the age of 21 can also come to the US. But you know, both your spouse, your children, they can study in the US. But unfortunately, your spouse cannot work in the US if you know, if your spouse is in the O1 dependent status. Perfect. And now let's discuss the EB-1A green card in a little bit. So the requirements, or kind of like the type of evidence you have to submit for the EB-1A green card is very similar to the O-1A, O-1B evidence. So I will not be going through that in detail. Again, you know, like you would have to show that you meet 3 out of 10 criteria. And you can, you know, easily find the criteria online, so we'll not be going through that. What I will discuss in a little bit more detail is kind of like the analysis the government does, you know, or conducts when reviewing the EB-1A visa petition. So the analysis is called Kazarian analysis, and the government basically, you know, does a 2-step analysis. So in the first step, you know, USCIS will examine the type of evidence you submitted and determine, you know, like if you have either won kind of like a major award, or, you know, like if you submitted evidence that you meet at least 3 out of the 10 EB-1A criteria. However, you know, like just because you submitted this evidence and you meet the criteria, like this will not be sufficient for, you know, to qualify for the EB-1A green card. So then the government moves to the second step of the analysis. And in the second step of the analysis, they will consider kind of like the overall quality of the evidence you submitted. So like, let's say that, you know, you submitted you know, evidence that there are, you know, you submitted evidence that there are like 30 published articles about you and your work. So in the second step, you know, so that would meet the first step, but in the second step, the government will basically look at, okay, you know, like what were the media, you know, like who published the articles about you. So like, let's say that you were able to submit evidence that there were articles from like Forbes, like New York Times, like really well-known media, like this would have much kind of like higher evidentiary value than, like if you submitted evidence that there were articles about you, but the articles were mostly, kind of like published in your home country and, from kind of like lesser well-known like newspapers or magazines. So, the second step, the government will kind of like look at all this and then make kind of like a final decision, final determination, like whether you are really kind of like one of the top people in the, like in your industry, and whether you have kind of sustained the national or international acclaim they want to see for the EB-1A. Perfect. And now Jiyae will talk a little bit more about the national interest waiver green card.
Got it. Thank you so much, Michaela. All right, so let's discuss the EB-2 NIW, which is another option that could be useful for, if you are interested in applying for a green card, but maybe your credentials are not at the level of the EB-1A yet, or if you're engaging in a particular area of the industry that is strategically important to the government, such as STEM technology, AI technology, things like that. Maybe the NIW could be a great option for you. So let's dig into the eligibility requirements and discuss how to qualify for the green card under the EB-2 NIW. And it is worth noting that you're able to self-petition for a green card under the EB-2 NIW category, which can be a huge advantage for some people. Now, the ordinary EB-2 category is usually when you have a U.S. sponsor, a company to sponsor you with a job offer, and they ordinarily need to go through what is called a labor certification requirement, which is the requirement to test the labor market to see if there are any U.S. workers who meet the minimum requirements to fill that job before offering that job to you. However, if you are able to convince the government that you merit a national interest waiver, then you don't need to go through all of that labor certification. You don't need a job offer. You don't need a U.S. company to sponsor you. You can simply self-petition for a green card through that. So let's dig into the requirements. So the first requirement is to meet the EB-2 category threshold. And this is the minimum before you even go to, the three-prong matter of Danaher test for the NIW. So you do need to show either that you have an advanced degree, which is defined as a master's degree or higher. So degrees such as a JD or MD, for example, also qualify as advanced degrees because you typically need to already have a bachelor's degree in order to gain admission to those type of degrees. Such as LLM, for example, that could work. An MBA could also work as an advanced degree. And if it is a foreign degree, you do need to get a U.S. education equivalency report from an accredited institution to prove that your particular degree is equivalent to a master's degree or higher in a U.S. University setting. So if you don't have a master's degree or higher, another way you can be considered to be an advanced degree holder, like an equivalent of an advanced degree holder, is by showing that you have a bachelor's degree in your field, plus 5 or more years of progressive work experience in your field following your bachelor's degree. And what does this mean, progressive work experience for 5 years? It means that your job duties and your responsibilities changed in complexity and seniority over time. So if you stayed in the same position and if your duties stayed the same throughout the 5 years, such as the progression was static, then unfortunately that will not be enough to meet the progressive work experience requirement. You do need to show in the form of employer confirmation letters, expert letters from your previous employers, for example, confirming exactly when you worked, and also confirming how your job duties and your responsibilities changed over time. So provided that you can give this evidence, then you could potentially meet the advanced degree threshold through a bachelor's degree plus the proof of the 5 years of progressive work experience in your field following your bachelor's. Now, if you don't have the master's, if you don't have the bachelor's, if you don't have the work experience, there is still another way, an alternative way you can meet the EB-2 threshold, and that is by showing that you have exceptional ability in the sciences, arts, or business. And to meet this threshold, you need to show that you can evidence under at least three out of the 7 criteria that is listed here. And this includes things like 10 years of full-time experience in your field, proof that you earn a higher salary than most others in your field, proof that you have received recognition for your significant achievements in the field by your peers, by industry organizations, by government actors, etc. And this can take multiple forms, such as if you, developed a particular technology that were mentioned in the media or resulted in publication of a patent, if you, published an academic article and that was cited a high number of times, all of those things can potentially be used as a form of recognition for your achievements in the industry. So provided that you have 3 out of the 7 criteria that you can provide evidence to, the general threshold you want to meet is that you want to show that you have a degree of expertise that is significantly above what is ordinarily encountered in the field. And hearing that phrase, you already know that it is a much lower standard than what the language that we use in the EB-1A context, extraordinary ability. Extraordinary ability in the EB-1A context mean you really need to reach the very, very top of your field. You need to be one of the small percentage that have reached the very top of your field and have received national or international acclaim for your achievements. Now, for exceptional ability, they don't require that. You just need to show that you have a degree of expertise that is significantly above what is ordinarily encountered in the field. But you do need to meet at least 3 out of the 7 evidentiary criteria listed here. So now let's say you have met the EB-2 threshold criteria. Then the other part of qualifying for the EB-2 NIW green card is showing that you qualify for an NIW. And as I mentioned before, there's a 3-prong analysis test that the government does. The criteria was promulgated by a case called Matter of Janisar, and it is a 3-prong test. So the first prong is that the applicant must prove that their proposed endeavor in the United States must have both substantial merit and national importance. So what does that mean? So substantial merit can be proven in a wide variety of fields, which can include business, healthcare, education, science, and technology. And endeavors that tend to further human knowledge in those key areas, including medical advances, improvements in engineering practices, and things like that, those tend to be endeavors that are likely to meet substantial merit. Now, when you think about national importance, really what the government is looking for is what is the future impact and how is that important to the United States as a whole, as opposed to just benefiting your immediate employer and just benefiting your immediate clients. So they're really looking for a broader impact to the industry, helping to advance the status of things, helping to advance best practices in a particular area of technology that is important to the government. For example, if you are someone who is an engineer who develops, designing semiconductor chips, for example, and if you developed a new technology where the chips can be designed in a more efficient way, having more data in a same area, same given area, those kinds of technology is really important to, help semiconductor companies in the United States stay competitive. And those are the types of endeavors that could be found to have national importance. Really, the question you want to ask is, what is the future impact of your work and how is that important to the United States? And sometimes it is helpful to, bring in government reports that talk about particular areas that the government is interested in investing in, such as, AI or environmental sustainability, electric vehicles and solar energy and things like that. So that can also be one way to figure out which areas the government is currently interested in. The second prong is that the person who is applying for the NIW is well positioned to advance the endeavor. And this can be proven by, showing the person's education background, experience in, the field that is relevant to the project that they're proposing to do in the United States. Really, what you want to do is to develop a record of success in previous related projects that is directly relevant to your proposed endeavor. And the third requirement is that, on balance, it will be beneficial to the United States to waive the requirements of a labor certification for this particular person. And this can be done in a couple ways. So one strategy is to rely on prong one, really emphasizing the broad impact, the broad systemic benefits that your work in the United States can bring to the field as a whole, beyond just benefiting your employer, beyond just benefiting your clients. You can also emphasize prong two, where you can talk about the unique know-how and experience that you have, which other U.S. workers with minimum qualifications may not have. So it may not be replaceable with just another U.S. worker who has the minimum credentials. Some special considerations are relevant for entrepreneurs. For example, if an entrepreneurial project stands to provide a substantial economic benefit to the United States, such as job creation and generation of tax revenues, especially in an economically underdeveloped area or economically depressed area with a high unemployment rate, if your project has the potential to revitalize those areas, that can also be a very important aspect of proving the third prong. On balance, it is beneficial to the United States to grant you the NIW. All right, so then let's shift gears a little bit and talk about expert opinion letters. Expert opinion letters are a very important part of all extraordinary ability petitions, including the O-1 categories, EB-1A category that Michaela just talked about, and EB-2 NIW petitions. And the reason why is because those letters really contextualize what is the original contributions that you have made to your field, which makes you either someone who has extraordinary ability that is set apart from others who are ordinarily practicing in the field, or in the case of an NIW, really gives more persuasion to the prospective impact that your work can have to the industry as a whole, advancing best practices as opposed to just, doing your job and benefiting your employer. So the purpose of expert opinion letters are a little different. For the EB-1A and the O-1A, you would want the experts to confirm that you have extraordinary ability in your field, setting you apart from others in your field, and is well known in the field, has sustained national or international acclaim in your field. For the NIW, some types of letters can really focus on the national importance of your proposed endeavor, such as if you can get a letter from an interested government agency, for example, or a local chamber of commerce, or a local government, official who works in the area that you're proposing to work in. Those types of letters can be very helpful in supporting national importance. Another type of NIW letters can really focus on your contributions to the field in the past. And that will really help bring out your particular skills that will render you well positioned to advance the endeavor. So those types of letters focusing on your past projects, a record of success, can support the second prong, well positioned to advance the endeavor. So it really is important to consider who you want to get the letters from, especially for the EB-1A, for the O-1s. You really need to get letters from leaders in the industry, key individuals who are working, in senior positions, like, high-level executive positions in well-known corporations, for example. If you're a business person, if you're an artist, you want to get, a letter from an artist who is leading in the field, who has that, already has that acclaim and recognition as a leading expert in your field. And we would typically also include the full curriculum vitae, the full resume of the person who is writing the letter, to really convince the government that these people's opinion can be trusted as a leading expert when they provide the assessment regarding your abilities and your achievements. So we talked a little bit about who is writing the letter and background information. Another type of letter is from people who you worked with in the past, or the people who you currently work for. So your current employer, your past employers can really provide the in-depth information of your contributions in the industry, which can be relevant for both, extraordinary ability and NIW petitions. So it is also important to think about how the individual knows you. So what I call independent experts and what I call inner circle experts, it is very important to have a mix of those kinds of experts. So inner circle experts are people who have worked with you in the past, such as your employer, your past employer, or past business partners, and they can speak to your achievements in great detail because they have personal knowledge of those projects that you have done. Now, independent experts are people who have not directly worked with you, but they do know you through your work or through your reputation in the industry. And then they can confirm the assessment that your abilities are outstanding in your field, or in the case of an NIW, they can confirm that your work stands to impact the field in a broad way. And it is important to have both inner circle experts and independent experts, because inner circle expert letters provide the granular detail, the very specific concrete detail about what you have done in each project, and sometimes can also be used to link your personal role to a very well-known project that is a larger project. Though there may have been many people involved in that project, but what was your role and how was that critical, right? So inner circle letters can help bridge that gap. Now, independent expert letters, they play a different role. And the important thing about the independent letters is that they are objective. So USCIS may rely a little bit more on independent expert opinion letters regarding, the value of your work, the contribution of your work to the industry, or, the merit of your work, your future work to the industry as a whole. Those types of national importance type arguments can really be persuasively made with independent expert letters, who are, leading experts in the industry that they don't personally know you, but they can objectively confirm that what you're doing is important. So it is good to have that mix of inner circle and independent letters. Now, then let's talk a little bit about the content of those expert letters. The discussion in the letters. What kinds of content does the letter need to contain? So one thing to note is that specificity is very important. And letters that are formulaic and simply repeat the regulatory requirements are not effective. So for example, like if the letters just say, oh, the applicant is a well-known and famous figure, or if the letter just conclusory statements like the applicant's project has national importance without giving any more detail, those types of letters are not going to be effective because USCIS, their approach is they don't need to rely on conclusory or general statements. So being very specific in the letters is very important. And one thing you can do is draw out specific examples of your past work, because those examples will support why you have extraordinary ability or why your project has national importance. So things that the letters can, questions the letters can answer include things like, what exactly did you do? What problem or limitation was the industry facing? How did you solve this problem in an original way? Why was this significant? And how was your work shared with other experts? And how was this work received by the public? So all of these details can be included in those letters, which can really support your case for either an NIW case or an extraordinary ability case. All right, so we will move on and think a little bit about the strategic considerations related to choosing which category you can apply for. We already discussed a variety of different options for extraordinary ability individuals. So let's go through some of the strategic considerations. So first question is, do you want to stay in the United States temporarily or permanently? And as Michaela mentioned in the previous slides, the O-1A and O-1B are non-immigrant visas. They are well suited for people who want to, temporarily work in the United States, and, maybe you want the freedom to spend long periods of time outside the United States in your home country if you continue to have a strong connection with your home country. That can be an advantage of the O-1A and O-1B. Now, it can also be faster to get. The EB-1A and NIW are immigrant visas, green card options. Green cards are typically slower in processing. So if you need to get into the United States fast and start working on your US-based projects, the O-1A and or O-1B could be a good option because non-immigrant visas tend to be issued faster than green card options. Now, EB-1A and NIW, as I mentioned, are green card categories and really meant for people who want to live in the United States permanently. Because a green card also, comes with a series of responsibilities, such as, tax-related responsibilities, and also there are some limitations to how long you can stay outside of the United States if you want to continue to maintain your green card. So there are some restrictions. So this really is an option that is well suited for people who want to live in the United States permanently. And if you're interested in U.S. citizenship, along the line, right? If you're in the United States and you have physical presence in the United States for 5 years, then you may have the option to apply for U.S. citizenship as well. So if that is one of your goals, then the EB-1A and NIW could be good options for you to pursue now. The second question, the strategic question you can think about is, do you have a U.S. employer or agent, or do you want to self-petition? So the O-1A and O-1B are visa categories that require a U.S. petitioner. So either the petitioner is a U.S. employer that wishes to hire you, or it can be a U.S. agent who will, coordinate your activities in the United States with different employers. Now, in the case of an entrepreneur, it is also possible for you yourself to create an entity, a US-based company, and that company can act as the petitioner to apply for the O-1A, O-1B petition on your behalf. So it is okay to set up a new company, and that company, if it is a US company, it is considered a separate legal entity from you. So if you apply through your US entity, that can also be an option, and that will not count as self-petitioning. Now, for the EB-1A and NIW, both categories do allow self-petitioning, which means the beneficiary, the individual, the foreign national, can be the driver of the petition. So the applicant himself or herself can self-petition for the green card under the EB-1A and NIW categories, and you don't even need a separate entity to do that for you. You can apply as an individual. So that can be a significant difference for some people. Finally, we can talk a little bit about family considerations. For the O-1A and O-1B, and Michaela mentioned this in previous slides, spouse and children under 21 can come to the United States on O3 visas as dependents. However, the spouse cannot have work authorization under the O3 category. Although it is possible to study in the United States, there is no work authorization option. Now, by contrast to that, the EB-1A and NIW are both green card categories. And once you are approved for a green card, your spouses and children can also apply for green cards as dependent beneficiaries. And if you are applying for an I-485, which is an adjustment of status application in the United States, and if your spouse is also applying for an I-485 based on the same approval, then the ordinary benefits of work authorization and travel authorization also can be pursued by the spouse. So the possibility of work authorization can definitely be a good advantage for those green card options. All right, so let's think a little bit about additional strategic considerations when you are moving from a non-immigrant visa to a green card. So the first thing to consider is differences in qualifications. So the EB-1A green card option, although the operative language is very similar to the O-1A or even O-1B, the EB-1A is practically judged with a much stricter standard as opposed to the non-immigrant O-1 visa options. So it is important to note that even though the language is very similar, qualifying for an O-1A or O-1B does not mean that you automatically qualify for an EB-1A. So one thing you can do is, for example, if you're jumping from an O-1B to an EB-1A, for example, you may want to first come to the United States on the O-1B and spend some time really building up your profile and accumulating the relevant evidence that will, strengthen your case for the EB-1A in order to, meet the higher threshold. So those kinds of strategic long-term plans can be made. Another consideration is timing regarding, your non-immigrant visa. Consider how much time you have left on your current underlying visa. Some visas are harder to extend or are subject to more scrutiny once an I-140 even application has been filed. For example, like a TN visa is one example with quite strict non-immigrant intent requirements. So if you're on a TN visa and if you apply for self-petition for an EB-2 NIW, for example, the next time you need to renew the TN visa at the border, you may encounter some challenges by the officer because of that, pending I-140 or approved I-140. They can think of that as an expression of immigrant intent, and it may be harder for you to renew or extend your TN. So in those kinds of cases, strategic timing could be helpful. You can maybe go ahead and extend the TN first, renew the TN first. And once you have 3 more years, then maybe you can, pursue the, green card options to avoid the risks there. The other consideration you can think about is family considerations with regards to timing. So if you have children who may also want the green card, aging out is a concern because after the child turns 21, the dependent green card option is no longer available. So that can be one way, that can be one reason why you may want to, hurry in filing the green card application and file it earlier than you may have wanted to. That can be one strategic consideration in your mind. All right, so the last topic we want to cover today is, are extraordinary ability categories available for entrepreneurs? And the answer is yes. And if we look at the EB-1A and the EB-2 NIW green card options, they both allow for self-petitioning, which means entrepreneurs can apply as individuals and self-petition for a green card based on that. There is no need for a U.S. job offer from a different company. There is no need for a sponsorship from a U.S. person. Now, another thing to note is there has been changes in the NIW adjudication standard under the Matter of Denisar case, which came out in 2016, which did make NIW a much more friendlier category for entrepreneurs, as the case law explicitly discussed that the NIW could be a good option for entrepreneurs who may not benefit from the traditional ways of getting a green card through U.S. sponsorship. And another thing that I briefly mentioned in the previous slide, but it is worth reiterating, is that it is possible to apply for an O-1A visa as an entrepreneur if you have a separate U.S. company that is acting as the petitioner, because those, if you set up a U.S.-based company, that is considered a separate legal entity, so that legal entity can petition your case. Now, one word of caution, though, is that there needs to be some degree of evidence that there is work in the United States for you. So it cannot really just be a paper company, right? It is highly recommended to, also provide evidence such as letters of intent or client contracts with your U.S. company to show that, this is a bona fide business project and there are, clients and, potential business partners who are interested in pursuing work with you in your area of extraordinary ability. All right.
Thank you so much, Jiyae. I think we have 2 questions. So the first question is, someone is asking if I work as data scientist in international development, can I qualify if I have masters in my field? I think probably for NIW.
I think maybe they're asking about the NIW. data scientist. So I would say it really depends on what your proposed endeavor is, right? And you really want to make sure that your degree is related to your proposed endeavor, which is, the basis of your claim for national importance, right? So yeah, the answer to this question, well, regarding the EB2 threshold, if you have a master's, yes, you can qualify, provided that you can get a US equivalency requirement if it is a foreign degree, but the degree must be related to your proposed endeavor, right? So again, this will depend on what your proposed endeavor is, and for that, definitely feel free to schedule a consultation with me or one of the other experienced attorneys in the firm, and we'll be happy to take a look. All right, next question. What if a person is already approved for an immigrant visa but is waiting for the category to be current? Can they, in the meantime, go to the US on a TN visa if they qualify for a TN visa? Yeah, so having an immigrant petition filed and approved is always kind of a risk factor in the TN context. So I mean, you can try, and there are some arguments you can make that you don't have immigrant intent for that particular visit, and you actually intend to leave. For example, if you intend to process the immigrant visa through your home country consulate as opposed to filing an adjustment of status, maybe you can try using that argument. But yeah, a word of caution that not all CBP officers would be appreciating that argument, and so there is a degree of risk when you're navigating the TN application. Where can we check what are the fields eligible for NIW? So there is no limitation to what kinds of fields are open for NIW. Now, there are some areas that are, more well-suited than others. And if you look at, critical and emerging technologies list, you can Google that, critical and emerging technologies, United States, and you will see a list of particular technology areas that the US thinks is important for national security. So if you can tie in your endeavor to anything like that, then maybe, yes, that could be, one positive way to argue that your work has national importance. But there can be a variety of, different fields where you can get NIW for, as long as you can prove that your work has a broad impact to the field, that your work will have broad impact to the field. So for example, if you're a lawyer and if you developed a particular area, a particular approach in law that has never been developed before, and you write articles about it, you are invited to speak about it in conferences, and you're really famous, and everybody is trying to do what you're doing. So things like that. If you have influence in your field, no matter what the field is, there is a possibility you could qualify for the NIW based on that broad impact requirement. It can be even in fields like culture and art. But really the important question is, what is the future impact of your endeavor?
Perfect. So I think these were all the questions. Thank you. Well, actually, I think
just a few more popped up.
Yeah,
for very specific fact-based questions, definitely the consultation is a way to go, because then we can look at your particular facts and advise you on the options that you may have. If I apply for NIW and get it approved, can I stay in the US automatically, or must I maintain a valid H-1B status until it is time for my priority dates to be current? So the answer for that, just filing the NIW I-140 underlying petition does not give you status in the United States. So that's a very important distinction to have, right? So once your priority date is current, you can file the I-485, and once you file the I-485, then you can continue staying in the United States. Now, having said that, if you are on an H-1B status, and if you have an approved I-140, there may be a way to continue extending your H-1B beyond the 6-year limit based on that I-140 approval. But definitely talk to a lawyer to really look at your particular facts in that case. What is the percentage of approvals for NIW? Regarding the government rate of approvals, I think it's somewhere around like 80 to 90% of all cases are approved. And yeah, we're not going to talk about our office approval rate, but we can definitely say that most of the cases that we file are approved.
Perfect. So I think these are all the questions we received. So thank you so much, Jiyae, for a great presentation. And thank you everyone for joining us today. Have a good day. Bye-bye.
Thank you. Bye.